A New York appeals court is telling Donald Trump to go away. Donald Trump filed yet another emergency appeal to the Appellate Division after the judge, Justice Merchan, presiding over the Manhattan District Attorney criminal case against Donald Trump, refused to entirely vacate or remove the gag order that was imposed on Donald Trump in connection with the Manhattan District Attorney criminal case where Donald Trump was convicted on 34 separate felony counts. You will recall that in the case, there was a gag order imposed on Donald Trump for making threats to 3 separate categories of protected persons: to the jury, to the district attorney and the court staff and the judge's family members, and to district attorney's staff, as well as to witnesses. Those were the 3 separate categories. Following Donald Trump's conviction on the 34 separate felony counts, Donald Trump petitioned to remove the gag order, saying that the trial proceedings had now ended, and Donald Trump wanted to attack all of those various classes of persons: the witnesses, the jurors, and the court staff and district attorney staff. Justice Merchan said, look, the proceedings are over, and while I don't want to remove the gag order, at least as it relates to the trial proceedings are over, so we will remove the gag order's limitations that preclude Donald Trump from speaking out against the jury and witnesses. So the judge modified the gag order and said, all right, Donald Trump, you can talk about the jury now. You can talk about witnesses now. However, sentencing still has not taken place. And because sentencing is part of the, quote, proceedings, we need to maintain the integrity of these proceedings. So you may not attack the district attorney's staff. You may not attack the district attorney's staff family members, nor can you attack the judge's, this court's family members the way you were trying to attack the court's daughter over and over again. So then Donald Trump was not satisfied with that outcome. He filed an appeal to the Appellate Division where he's previously lost over and over again, and the Appellate Division handed Donald Trump another loss this week. So Donald Trump did not get what he wanted. Donald Trump wanted to be able to attack the judge's daughter. Very odd thing to want to do. And Donald Trump wanted to be able to attack the district attorney's staff members and their family members as well. And the Appellate Division said, sir, you know how Donald Trump goes, he said, sir, you're a convicted felon, sir, and the proceedings are not over, so the gag order remains in place. Let me just get to the kind of meat of the ruling, if you will, and then I'll talk a little bit more about it, but let's get right to the meat of the ruling. Petitioner, Donald Trump, this is what the Appellate Division saying when they denied or rejected Donald Trump's request. Petitioner Donald Trump's contention that the conclusion of the trial constitutes a change in circumstances warranting termination of the remaining restraining order provision is unavailing. Courts are empowered to protect against the unfair administration of justice. The fair administration of justice necessarily includes sentencing, which is a critical stage of the criminal proceeding. A criminal action terminates with the imposition of a sentence or some other final disposition in a criminal court. See New York law, CPL section 1.20. Neither of which has occurred here. Accordingly, since the underlying criminal action remains pending, Justice Merchan did not act in excess of his jurisdiction by maintaining the narrowly tailored protections in paragraph B of the restraining order. Just so you remember, that relates to Trump's threats and attacks on the district attorney's office and staff members and the judge's family members. That's what subsection B is. Contrary to petitioner Donald Trump's contention, the people's evidentiary submissions in opposition to his motion in the Supreme Court, referring to the New York Supreme Court, which is their trial court, demonstrates the threats received by the district attorney staff after the jury verdict continued to pose a significant an imminent threat. We have considered the petitioner's remaining arguments and find them unavailing. This constitutes the decision and order of the Supreme Court Appellate Division, First Department. So there, what the Appellate Division was also saying is that Donald Trump's claim that the threats have abated, the threats have went away since Donald Trump was convicted, are false. There are still threats as a result of your actions, Donald Trump. And the court, Justice Merchan, the judge presiding over the case, did the right thing in having a narrowly tailored gag order that relates to the remaining elements of that exist now that the proceeding is still taking place.
Hey fam, it's your big boy Bugsy from your favorite new show, Felt the Nation. New episodes every Friday at Fight for Progress. And while I'm here, let me ask you, do you ever feel like you just fell out of a coconut tree? Do you feel like you don't exist within the context of all in which you live and what came before you? Well, try this new Go Cocoa Nuts energy drink. We are never going back to being tired.
Going to the other aspects of this order, the court talks about the posture within which it was brought before the Appellate Division, pursuant to CPLR 7803, challenging the Supreme Court, New York's order entered June 25th, which, among other things, denied in part Donald Trump's petitioner's post-trial motion to terminate the orders entered March 26, 2024 and April 1, 2024, insofar as paragraph B of the restraining order limited his ability to make certain public statements about the court staff, the district attorney's staff, and family members of the court, the district attorney and their staff, and extended this limitation through sentencing, unanimously denied and proceedings dismissed without cost. Petitioner Donald Trump asserts a cause of action for judgment pursuant to CPLR 7803. This section is a codification of the common law writ of prohibitions. And just to get through this area of kind of lots of law here, all the court's saying here is that you're seeking an emergency writ saying that Justice Merchan acted in excess of his authority. And that's you really have to show a very high burden of proof that a judge is acting in excess of their authority if you want us, the Appellate Division, to overturn what Justice Merchan did. Then it goes on to say, in Trump's prior Article 78 proceeding, challenging the restraining order, this court held that Justice Merchan properly weighed petitioner's First Amendment rights against the court's historical commitment to ensuring the fair administration of justice in criminal cases and the right of persons related or tangentially related to the criminal proceedings from being free from threats, intimidation, harassment, and harm. Pause there. So what is the Appellate Division, the Court of Appeals, basically saying right there? They're saying, you tried this before, Donald. You brought this before us when the case was pending, and we found that a gag order imposed on a criminal defendant like you, now you are a convicted felon, at the time you were a criminal defendant, we found it's a proper exercise of the administration of justice by a judge to balance this and protect people who are in a court proceeding from you, the criminal defendant. Then the court goes on to say, following the verdict, Justice Merchan granted so much of petitioner's motion to the extent of terminating the provisions of the restraining order, governing his statements about trial witnesses and the jury. Pause there. The Appellate Division says, Donald, after the verdict, once you were found to be a convicted felon by a jury, you petitioned to Justice Merchan to remove the restraining order. And Justice Merchan said, look, now that the trial's over, the witnesses and the jury are no longer part of the proceeding. Reluctantly, the gag order can't apply to them. So you got what you wanted there, but now you still want to attack the district attorney's family members and the court's family members and staff members while the proceeding's still pending? We are not going to allow it. That's why Justice Merchan retained paragraph B of the restraining order, finding that the court and the district attorney staff covered thereby must continue to perform their lawful duties free from the threats, intimidation, and harassment until sentencing. So we've considered your arguments, Donald, and we are denying them. It's worth noting here very quickly, too, that one of the things that Donald Trump did was have his surrogates go out and attack Justice Merchan. So Donald Trump would bring in MAGA Mike Johnson, Lauren Boebert, Matt Gaetz, and all these MAGA Republicans who would go and then just do the attacking on Donald Trump's behalf. That's how Donald Trump wanted to get around it. And then because these members of Congress have speech or debate clause immunity, that they really couldn't then be, brought before the court and challenged for their behavior. Also, Donald Trump relies on surrogates like Laura Loomer. And we've been talking a lot about Laura Loomer on the MeidasTouch podcast because she's one of Donald Trump's top surrogates, and she's out there saying the same types of vile things she would say about Justice Merchan's daughter and other judges' family members for Donald Trump. She's saying those things now about Vice President Kamala Harris, and Donald Trump keeps giving Laura Loomer shout-outs. You're doing great work. Keep it up, Laura. You're doing a wonderful job. And you may remember that I've been talking about that in a bunch of the other videos we've been working on. So another loss for Donald Trump. The gag order remains in place. He loses in the Appellate Division. We'll keep you posted, though, on more developments here on the MeidasTouch Network. Hit subscribe. Let's get to 3 million together. Thanks for watching.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.